On the 7th of June 2020, in the course of a Black Lives Matter protest in Bristol, a monument of 17th century slave trader Edward Colston was pulled down and thrown into the harbour side. Subsequently, 4 of those involved, Milo Ponsford, Sage Willoughby, Rhian Graham and Jake Skews, were charged with criminal damage. On the 5th of January 2021, following a trial at Bristol Crown Court, all 4 were found not guilty by the jury. This video is a spoken version of a blog post by the Secret Barrister. I'm not the Secret Barrister, but I speak with their voice and with their permission. The Secret Barrister is an anonymous junior barrister specialising in crime and the author of Stories of the Law and How It's Broken and Fake Law. Links are below. I'm Barrister Daniel Barnett. I specialise in employment law and I present the Legal Hour on LBC Radio. Criminal damage is defined in the Criminal Damage Act 1971. Section 1.1 provides a person who, without lawful excuse, destroys or damages any property belonging to another, intending to damage any such property, or being reckless as to whether any such property would be destroyed or damaged, shall be guilty of an offence. Now, in a Crown Court criminal trial, the prosecution has to prove the case by making a jury sure of guilt. That used to be formulated as beyond reasonable doubt. A defendant, the person who's charged, doesn't have to prove their innocence. For a charge of criminal damage, therefore, the prosecution has to prove 4 things. First, the defendant has damaged property. Second, the property belonged to another. Third, the defendant intended to damage the property or was reckless as to whether it would be damaged. And fourth, the defendant did not have a lawful excuse for damaging the property. The defendants all admitted their part in pulling down the statue. It was accepted that Ms. Graham and Mr. Ponsford had brought ropes to the scene. It was accepted that Ms. Willoughby had climbed the statue to pass ropes around its neck, and it was accepted that Mr. Skews had encouraged the crowd to roll the statue into the harbour and into the water. The prosecution case was that these 4 defendants were acting together and jointly with others, meaning that the prosecution didn't have to prove that each defendant personally caused damage to the statue. It was enough if a defendant deliberately assisted or encouraged others to damage it, say by providing ropes to be attached to the statue. But it's wrong to say, as has been widely reported, that the defendants admitted criminal damage. They didn't. Looking at our checklist, while there was no dispute that the statue belonged to another, to Bristol City Council, which held the statue in trust on behalf of the people of Bristol, the other elements of the offence were challenged. 3 of the defendants argued that Colston's statue had in fact not been damaged, because damage is defined as temporarily or permanently physically harmed. They argued its value had increased as a result of it having been pulled down, salvaged and restored in a museum. It follows they did not accept intending to damage the statue or being reckless as to whether it was damaged. But the key issue raised by all defendants relates to that phrase, without lawful excuse, from section 1.1. Because the case for all the defendants was that even if damage had been caused, it wasn't unlawful. And this is where things get interesting. Section 5 of the Criminal Damage Act 1971 provides examples of what might amount to a lawful excuse, but it's not exhaustive. There are also a number of cases from the High Court and the Court of Appeal which clarify what might and what might not amount to a lawful excuse. For instance, damaging property because you believe you are carrying out God's will is not a lawful excuse, nor is damaging a wheel clamp after you've parked your car in a private car park with a clear warning that your car will be clamped. Now, in this case, 2 lawful excuses were raised, and the judge agreed they should be left for the Bristol jury to decide. First, that reasonable force was used to prevent a crime. That was the first lawful excuse which was relied on by the defendant. It's well established both in our common law and in legislation, section 3.1 of the Criminal Law Act 1967, that a person is entitled to use reasonable force to prevent the commission of a crime. All the defendants argued that the public display by the council of the Edward Colston statue was itself a crime, or potentially two crimes. First, it was said that displaying the statue amounted to an offence of displaying indecent material, contrary to Section 1 of the Indecent Displays Control Act 1981. And second, it was said that there was an offence of displaying a visible representation which is abusive within the sight of a person likely to be caused distress by it, contrary to Section 5 of the Public Order Act 1986. Now, it was this element of the case that resulted in expert evidence being given by historian Professor David Olusoga, who detailed the history of Edward Colston, the role that the Royal African Company, of which Colston was CEO, played in enslaving and shipping African people, and of the violence and brutality inflicted by the Royal African Company upon tens of thousands of enslaved people. It was argued by the defence that the public display of a memorial to Colston was therefore both indecent and abusive, such as to render it criminal under the two acts I've just mentioned. Now, when considering this defence, there were three key questions for the jury. Did the defendants honestly believe that a crime was being committed? By the way, the question isn't whether a crime had been committed by displaying the statue, but whether the defendants honestly believed that a crime was being committed. Second, were the defendants' actions done in order to prevent one or both of those crimes? And third, if so, did the defendants' actions amount to the use of reasonable force in the circumstances that the defendants perceived them to be? Now, the prosecution case was the answer to those questions should be no. And as mentioned a moment ago, and as I'll repeat throughout, the prosecution has the burden of disproving the defence. Now, the second lawful excuse defence, which is set out in Section 5 of the Criminal Damage Act 1971, was owner's consent. This was raised by two of the defendants, who said they honestly believed that the statue was owned by the people of Bristol, and that had the people of Bristol known of the circumstances, they would have consented to pulling it down. The prosecution case was that the defendants didn't actually believe that, and that they'd taken no steps to consult the people of Bristol. Again, the burden was on the prosecution to disprove the defence. If there's any doubt, the defendants are entitled to the benefit. Now, that's the cornerstone of our justice system. So if the jury were sure that damage was caused, and sure that there was no lawful excuse, they had to convict the defendants, right? Well, if the jury rejected all of the other defence arguments, there was one final issue for the jury to decide. And to put it in its simplest terms, it relates to the right to freedom of thought and conscience, and the right to freedom of expression. These rights, the courts have long held, protect not only beliefs such as anti-racism, but actions associated with protest. Because the damage, or the alleged damage, was caused in the course of a protest, these rights were engaged in this trial. Now, this doesn't provide a trump card. You don't have an automatic defence to a criminal offence simply because you were acting in accordance with your beliefs or exercising your right to protest. Limitations on those rights, such as laws preventing criminal damage, are permitted. But, as the Supreme Court recently confirmed, when considering whether a lawful excuse exists for potentially criminal acts committed in the exercise of those rights, the courts are required to consider whether convicting the defendants would represent a proportionate or disproportionate interference with the exercising of those rights. Let's rephrase that. In other words, is it necessary in a democratic society, in the interests of public safety or for the protection of rights of others, that the defendants should be convicted for their actions? Now, answering this question requires the jury to balance the rights of the statue owners not to suffer damage to their property with the rights of the defendants to act according to their beliefs. And as the judge directed the jury, everybody in this country enjoys these rights. And the jury were expressly directed that the question isn't whether the jury agreed with the defendant's actions or aims, To put it even more simply, if the jury were sure that the prosecution had made them sure of guilt, they would also need to be sure that a criminal conviction for criminal damage would be proportionate. I'm going to say that again. If the jury were sure that the prosecution had made them sure of guilt, they would also need to be sure that a criminal conviction for criminal damage would be proportionate. In this exercise, the jury were directed to consider the following list. It's a non-exhaustive list of factors, drawing on the Supreme Court judgment: the extent of the interference with the rights of others, notably the rights of Bristol Council and of other Bristolians on whose behalf they held the statue in trust; whether the defendant or defendants believed in the views which motivated their actions, whether those views relate to very important issues, the importance to the defendants of the method of protest adopted, and whether their actions were directly aimed at the matter of which they disapproved. Also, whether the defendant's actions presented a danger to public safety. We don't know. We'll never know, because jurors are not allowed to disclose details of their deliberations or to give reasons for their verdicts. All we know is that the jury were not sure that the prosecution had proved its case, or, alternatively, the jury were sure the case had been proved, but were not sure it would be proportionate to convict the defendants. And that formulation is key. The defendants didn't have to prove they were acting lawfully. The prosecution had to prove they were not. That's not a glitch, it's not a technicality, it's how the foundation of our system works. The trial has widely been appropriated as a proxy battle in culture wars. Those who believe it was wrong to pull down the Colston statue see the verdict as an affront. Their grievance has been inflamed by comments from politicians and media commentators which misunderstand or misrepresent what the case was about and what the verdicts mean. So, for example, former Cabinet Minister Robert Jenrick tweeted, "We undermine the rule of law, which underpins our democracy, if we accept vandalism and criminal damage are acceptable forms of political protest. They aren't, regardless of the intentions." Meanwhile, Ipswich MP Tom Hunt declared himself deeply concerned at the precedent set here, and his colleague Michael Fabricant suggested he'd bring the intellectual might of the Home Secretary to bear on the case. On behalf of the government, Transport Secretary Grant Shapps appeared to agree there was a loophole that the government would look to fix. And the Prime Minister waded in to opine that it was wrong for people to go around seeking retrospectively to change our history. Now, for reasons we'll look at in a second, very little of that is true, very little of that is accurate. It's not all one-sided though. Public understanding of the case hasn't been helped by some of the responses supporting the verdict. Professor Olusoga, for example, told the BBC, and I quote, "An English jury has come to the conclusion that the real offence was that a statue to a mass murderer was able to stand for 125 years, not that the statue was toppled in the summer of 2020. Similarly, one of the defence legal representatives has been quoted as saying that the jury, quote, determined that a conviction for the removal of this statue that glorified a slave trader involved in the enslavement of over 84,000 black men, women and children as a most virtuous and wise man would not be proportionate," end quote. Now, neither of those, with respect, are quite right. The jury might have reached either or both of those conclusions, certainly, but we can't say for sure. It's equally as possible that the jury thought that toppling the statue was a dreadful act, but couldn't be sure any damage was actually caused. Or that the jurors personally took no offence to the statue, but accepted that the defendants might have genuinely and honestly believed that the display of the statue amounted to a criminal offence. To labour the point, but it is an important one for both sides to remember, there were multiple routes here to a not guilty verdict in this case. We simply don't know which one the jury took. For what it's worth, and remember I'm speaking on behalf of the Secret Barrister, I've long been in favour of requiring juries to provide reasons for their verdicts to reduce this sort of confusion generated by binary jury verdicts, but this is a controversial view among criminal lawyers. Is there a loophole in the law? Well, just before I answer that question, please do take a moment and like this video, and subscribe if you'd like to see more Legal Explainer videos. I'll give you 4 seconds. 4, 3, 2, 1. And while you're at it, maybe hit that notification bell as well, please. It helps other people find these videos. Now, there's no loophole that anybody who has been complaining about loopholes has cared to identify. And there isn't one as far as I can see. There were some very clever legal arguments advanced by the defence and accepted by the judge, but that is, unsurprisingly enough, what lawyers are for, to make submissions on how the law should be applied. This is how criminal trials work. Lawyers contend for an interpretation of the law that supports their case, and judges apply established legal principles to reach a ruling. For completeness, it should be noted that there were other, even more ambitious legal arguments made by the defence, which the judge rejected. Might it be argued there's something unusual about an acquittal on the basis the jury was sure of guilt, but not sure that a conviction would be proportionate? Possibly, if, and as I've stressed, we don't know, if this was the basis of the acquittal. But this isn't a legal proposition pulled out of the sky by a tricksy defence lawyer and an uber-woke trial judge. It's been set down by our highest court, the Supreme Court, and it's a protection that applies to all of us, not just the Colston 4. Is this outcome an affront to the rule of law? Well, not on any sensible interpretation. The rule of law holds at its heart that the law applies equally to all of us. The same legal principles apply whether you're a Black Lives Matters protester pulling down a statue or an anti-communism campaigner taking a pop at the Karl Marx monument. Many people appear to have mistaken the rule of law with an outcome I agree with. But there's another important point here. Even if the jury had been sure of the defendant's guilt and had been sure that a conviction would be proportionate, our system still doesn't compel a jury to find defendants guilty. Since the 17th century, juries have been entitled to acquit a defendant for any reason. They're not explicitly told this. They're directed by the judge that they must reach verdicts based on the evidence they've heard. But a judge cannot force a jury to convict. So the jury retains the prerogative to acquit, irrespective of the strength of the case against a defendant, and the courts can't interfere. Sometimes this is referred to as a perverse verdict or jury nullification. The principle's actually embedded into our common law. One of the strongest arguments in favour is the protection that the jury affords the individual from the power of the state. It means that if you are tried under an unjust law, your fate is ultimately in the hands of your peers, who can mark their displeasure by an acquittal. There are, of course, arguments against this, including that a perverse acquittal runs counter to the oath that every juror swears to return a verdict according to the evidence. But it's part of our law. It has been for centuries. And as a long-established prerogative of the jury, it's impossible to see how its exercise, if that's what happened here, can be described as an affront to the rule of law. Now, allied to these criticisms has been a suggestion from certain commentators that it was somehow inappropriate for the jury to apply values in this case. This criticism is the rather regrettable sort of fallacy you risk when you seek opinions from criminal law commentators with no experience of the criminal courts. But it's hard to convey in sober terms how utterly bonkers this proposition is. Value judgments, concepts of how much force is reasonable, or whether a person has an honest belief in something, and whether a statue of a slave trader is indecent or offensive, and whether a criminal conviction is proportionate to the alleged wrong, these are quintessentially jury issues. They arise in all sorts of criminal cases, along with other judgments that jurors are asked to make. Was this type of conduct dishonest? Was this person's belief and consent reasonable? And they feed into the very reason we've retained juries in criminal courts. We explicitly ask jurors to pull their experience and their values and to apply them to the questions that the law asks them to decide. Again, it's not an assault on the rule of law. It's just the criminal law in action. What does, however, represent a genuine threat to the rule of law is when elected politicians, having not heard the evidence, having not bothered to understand the relevant legal principles, attempt to undermine the verdicts of independent juries when the outcome of a criminal case doesn't meet with their approval. That is a very dark road indeed. Does this create a precedent? Does it mean that anyone can now pull down a statue of someone they don't like without consequence? No, and no. Jury verdicts create no precedent in law. If a case with exactly the same facts were tried tomorrow by a different jury, that jury would be entitled to convict. If you pull down a statue and the Crown Prosecution Service concludes there's evidence to support a charge of criminal damage and that it's in the public interests to prosecute you, you will be prosecuted for criminal damage. You'll be at liberty to plead not guilty. You'll be tried by a jury of your peers, during which you'd be tried according to the same standards and under the same law as the Colston Four. Whether you'd be convicted, and if so what your sentence would be, would entirely depend on the facts and circumstances proved by the evidence. There's never a guaranteed outcome with a jury trial. That's our system, people. I'm Barrister Daniel Barnett, and I've been speaking on behalf of and with the voice of the Secret Barrister, the anonymous blogger and commentator. Links to their books and to their blog and to their Twitter feed are below. You can see more Secret Barrister videos here, and this is another video you might like. Thank you so much for watching. Bye bye.